I warned him about this situation. This process is also in Wayne County. He's being sued. We can continue this all day. I also will add you to the case if you want to continue this. This needs to be dismissed today. Today.
This case opens with immediate tension, warnings, dismissals, and a courtroom already on edge. We're thrown straight into a legal storm involving the city of Detroit and Grayson Bay, where jurisdiction, identity, and compliance are all about to collide. Notice how quickly the judge pushes toward dismissal while the defendant refuses to back down. The big question is this a routine traffic matter, or the start of a much bigger legal confrontation? Stick around, because this escalates fast.
City of Detroit versus Javar.
Here we see a classic courtroom moment, an officer presenting fines and resolution options, while the defendant flat out refuses to accept the offer. Legally, this is critical. The court is giving an opportunity to settle before trial, which is standard procedure. But refusal shifts everything into a full contested hearing. The tension rises because the judge is now forced into trial mode. The key question here, was rejecting the offer strategic, or is this just escalating consequences unnecessarily?
Grayson, case number SP 1463900, counts 1, 2, and 3. SP 146409991. SP 146436761. Appearance for the record, please.
Grayson Bay.
Sherika Harris on behalf of Mr. Grayson Bay.
All right. Good morning to you, sir.
Your Honor, I'm going to represent myself in this matter. And for the record, my name is Grayson Bay.
All right. City of Detroit versus Javar, Grayson Bay. I'm trying to get Mr. Ambrose out of the breakout room, Ms. Snyder. Your offer, sir, is a $240 fine, failure to display, and a seatbelt ticket. You pay those, we'll close the other matters out. That will abstract to the Secretary of State. And then the seatbelt ticket is $65. So $240, $65. We'll close the matters. We'll close the matters out. That'll be a failure to display. It will abstract, but it won't carry any points. And today is the date and time set for a trial.
Your Honor, today was supposed to be set for trial, and I don't consent to any of this.
Okay, it is set for trial. I just gave you your offer so that you can you go in? Okay, there. I just gave you your offer so you could.
I'm not accepting that. I won't accept that offer.
Mr. Corporal Ambrose, can you put your appearance on the record, please?
Now the defendant challenges jurisdiction entirely, arguing he is not the correct legal person before the court. This is a common but controversial defense tactic in lower courts. The judge directly denies the objection, reinforcing authority over the case. Legally speaking, courts usually determine jurisdiction based on identity records and citations, not self-declared status. But here's the real tension: is this a legitimate identity dispute, or a procedural delay tactic? What do you think? Should courts pause for identity claims like this?
Brian Ambrose, Detroit 415.
Good morning to you. Okay, let's go. Are you ready to proceed, Corporal Ambrose?
Yeah.
Your Honor, I would object to holding this trial. I believe he stated that he's a different person. We have a ticket for a Mr. Javar Grayson. Grayson Bay is an entirely different person. We don't have jurisdiction over. We don't have a case over. I would object to holding that trial.
I'm going to deny the objection. He just said he's Grayson Bay. Just I don't think he's objecting to the fact.
I object to that, Your Honor. I'm objecting, and I also questioning jurisdiction.
Okay. Well, I'm denying your motion about jurisdiction, sir. The court has jurisdiction over you, so let's. Are you ready to proceed, Mr. Grayson Bay?
No, I'm not. I object to anything that you call yourself.
Things escalate dramatically when the defendant begins referencing lawsuits, notices, and claims of prior legal warnings. This is where courtroom procedure clashes with personal legal strategy. The judge essentially shuts it down, stating the case will not be dismissed. Legally, outside lawsuits or notices do not automatically stop municipal proceedings. But emotionally, this moment raises stakes, because now it feels like parallel legal battles are forming. Is this strengthening the defense, or complicating it further?
Also, I like to add that I sent this Brian and brochure. I sent him a COL. It's a cut-off law form. I warned him about this situation. This process is also in Wayne County. He's being sued. We can continue this all day. I also will add you to the case if you want to continue this. This needs to be dismissed today. Today. Now we're seeing Brian Ambrosius in 3 weeks in Wayne County.
All right. Well, let's go ahead and proceed because it's not going to be dismissed today. Okay.
Well,
so you can do what you want to do over in circuit court.
This segment is one of the most complex moments: identity confusion in open court. The defendant acknowledges the name but reframes it in philosophical/legal language, while the court tries to proceed with practical identification. The judge ultimately treats the identity as established for trial purposes. Legally, courts rely on official records, not self-described identity interpretations. But the tension here is huge, because the entire defense strategy hinges on this argument. Do you think identity disputes like this should delay proceedings?
Then have your way. That is your right. I don't know how you're proceeding in circuit court when you feel that this court doesn't even have jurisdiction over you. So let's go ahead and proceed. Corporal Ambrose, you want to speak with them before we proceed, Ms. Snyder?
Yes, Your Honor, and I do think we just need to clear up on the record that Your Honor has denied my motion to not have this matter heard today based on this defendant saying he is not the defendant before us. And also that defendant has agreed that he is not the defendant before us, but Your Honor is telling us to still do this trial. I need to make sure that's clear on the record.
Yeah, I don't think that he's denying that he's not Javar Grayson Bay. Are you denying that you're not Javar Grayson Bay, sir?
I am the living person, Grayson Bay, in living form. Javar Grayson is an artificial.
However he wants to articulate it, we'll let him articulate that. He's Grayson Bay. He's Javar Grayson Bay. His mom gave him that name. I don't think that's any dispute. Okay, so
that name has a social security card attached to it. It also has.
I think it's going to be pretty quick, Ms. Snyder. I'll put you in a breakout room with Corporal Ambrose and put it that way. It is just an expired plate, a seatbelt ticket, no proof of insurance. What is this other thing? Refuse to exhibit license and a false information ID. So just join the break.
Now we enter a more technical legal phase: interlocutory appeal arguments. The prosecution is trying to justify why the court should rule on jurisdiction-related concerns before final judgment. The key legal idea here is substantial harm, whether delaying appeal would cause damage. The argument presented is that ongoing filings and legal challenges justify immediate clarification. However, the judge questions actual harm to the city. This is a classic legal clash: efficiency versus procedural completeness. Which matters more in your view, speed or absolute legal clarity?
Breakout room, have a conversation with Corporal Ambrose, and then we'll just hear it. And if he has a right to remain silent, he says he doesn't want to be represented by a lawyer, and you can just put your case on the record, and I'll have to make a decision based on that. Right. Rejoin the room, please. I'm gonna pass the matter, Mr. Grayson Bay, and give them opportunity to talk. Okay. All right. We're gonna get her the ticket, give her an opportunity to speak. Are we ready, Ms. Snyder? Okay.
My supervisor has advised me to file an interlocutory appeal, Your Honor.
An interlocutory appeal on my motion, on your motion?
Yes, Your Honor.
Okay.
Or I suppose time to brief the issue, maybe on this record, or I'd leave in your honest discretion.
Let's see does that interlocutory appeal, if that is,
I'm sorry, Your Honor. Are we back on the record for Grayson?
yeah, let's go back on the record with Mr. Jabbar Grayson Bay. Now, is that interlocutory appeal? I mean, I have to proceed. I mean, I got the discretion of whether I want to allow you to do that or not, or just proceed, and you can file your appeal. Correct? And give me the law on that. You're muted, Miss. You're muted, Miss Snyder.
I'm sorry, Your Honor. My supervisor's talking to me over the wall, so it's hard to hear two people at once.
Okay.
The court rule is, I think she might be coming back. It's MCR 7.205.
I think you'd be quiet.
MCR 7.212C. 212C.
Maya, come here. Can't turn this on the floor. Pantry and then the kitchen. Go get a can.
Hurry up. 205, application for leave to appeal, and you said, what was the citation? What were the other?
7.212, but that's just saying the format for briefs.
I have 7.205 as application for leave to appeal. And this is Court of Appeals.
You have 21 days.
Appeals to Circuit Court, 7.105. 105. So 7.105 application for leave to appeal. I'm reading from paren B. 1D. If the order appealed is interlocutory, setting forth facts showing how the appellant would suffer substantial harm by awaiting final judgment before taking an appeal.
Yes, Your Honor. So my answer to that, I just made it to that part of the order too. My answer would be that the people would suffer harm because the defendant has already stated that he is filing what we believe, of course, to be frivolous, but the facts will prove themselves as they go.
Hold on, you broke up a little bit.
Can you repeat the last few words? I'm sorry, you broke up during the statement.
We believe that the substantial harm that the people would suffer would be the defendant has already stated he's filing numerous lawsuits against the court, against the parties, against the officer. We believe we'd be giving him a golden parachute. It's just one more issue to add to his level of appeals. This is one issue that needs to be clarified. Of course, he will be found, I believe, through fingerprints to be either the person given that ticket or Javar Grayson, the person given the ticket, will be given a capias warrant and we can move on. But I do believe that this issue needs to be handled before we make a further record. I have a duty to mitigate the city's damages. And I believe that's what we're doing and what I was advised to do by my supervisor.
But how would the city be harmed at all if we proceed? What would be?
The judge delivers a pivotal reasoning moment here, stating there is no sufficient legal harm to stop proceedings. This is important because courts generally favor moving forward unless a strong procedural barrier exists. The judge also emphasizes recognition of the defendant's identity through interaction and case records. Legally, this reinforces court authority over self-representation disputes. But this is also where strategy diverges. The defense is focused on jurisdiction, while the court is focused on efficiency. Who has the stronger legal position at this stage?
Any harm for the city, especially if you acknowledge the fact that you think that by fingerprints that would be Mr. Javar Grayson.
But Your Honor, what we think and what we can prove as a matter of the record and as the court of law is different. I do understand. I believe he's being frivolous. I think he is wasting the court's time. But I do think that as lawyers, as a court of law who do have to face appellate issues, this is something that we need to clear up on the record and have a clear record, such as a chain of custody of who Mr. Grayson is. I don't think it would take that long. Or we could solve this today with giving Javar Grayson a capias warrant and let Bay, whoever he may be, go on about his business. Either or. But I do think that having this trial over both of our objections is not the correct answer.
I just don't feel. I just don't feel.
You can't stand
one. I don't see any harm in proceeding. He's already indicated that he is Javar Grayson, except he wants to be acknowledged as Javar Grayson Bay, or he's the living. I don't know how he termed it. Person of Javar Grayson Bay. I don't think that, as a matter of fact, when Corporal Ambrose came in the room and introduced himself, I saw Mr. Grayson Bay sort of kind of had a look on his face. And to me, I took that look as he knows Corporal Ambrose. And there's no question. I haven't asked Corporal Ambrose if this is the person that he pulled over, but I'll definitely let you ask Corporal Ambrose that. But I don't think that there is any sort of identity issue here. I think the issue comes into something that we've seen probably, I don't know how many times, and I'm sure we're going to see it more in the future. And I agree that those things are frivolous and they do not apply. So I don't see anywhere where we can't proceed with this. Not unless Corporal Ambrose says that to you and through you that this is not, I don't recognize this person that's here. And was this not the person that, or even if there was, I would even allow Mr. Grayson Bay to put on a identity defense and say that wasn't me. He did that wasn't the defense. I don't know what his defense is going to be.
Your Honor, may I?
No, you can't. No, you can't. No. When I ask you to, when I want you to speak,
no
I'll allow you to speak. I'm going to give you that opportunity.
No problem.
So to settle this matter about your objection. It's like if the court rules bound me not to proceed because you wanted an interlocutory appeal, then that would be the court rules would bind me to do so. But I don't know of a court rule that's going to bind me not to appeal. And I just don't see in what harm it will be to any other parties, the defense or the city, by us proceeding in this fashion.
The case concludes with structured scheduling, motion deadlines, responses, pretrial dates, and a final jury trial setting. What stands out is how methodical the court becomes after initial chaos, bringing order to a highly contested proceeding. Legally, this ensures both sides have procedural fairness and time to prepare. But the bigger takeaway is this: even chaotic courtroom arguments eventually get reduced to strict timelines and rules. If you found this case as intense as it unfolded, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.